person or just talk to that person is such an empty feeling. I so wish I could go back and change things so that she was still here. I would trade my life so that she could be here if it were possible. I know that you have all suffered from her loss, and I have prayed for you and your family during this time so that you can, that God could help you. Nothing I can do will change the outcome. I can only tell you I have cried and I feel horrible for my actions. Please accept my humble and sincere apology for this tragedy.
Thank you. So, defense, have anything else they'd like to have?
Not for witnesses, Judge, no.
Okay. Any argument you'd like to make as to what the appropriate sentence should be?
Yes, sir. Briefly, and I filed a motion for downward departure. Does the
Yes,
court need, have you seen it? Do you need a copy of it?
I've read it. Thank you.
Okay, so I'm just going to go down through the various grounds, and I think this would apply to paragraphs 3A, 3B, and 3E specifically. So just briefly, Judge, we heard from Dr. Castillo. I mean, obviously she testified that Susan Lorincz suffers from chronic PTSD that's not related to substance abuse or addiction, and she's very amenable to treatment in regards to medication and therapy. Ms. Lorincz has had a hard life, and all the traumatic experiences that she has dealt with leading up to this incident affected her capacity to appreciate the criminal nature of her conduct due to the chronic PTSD. In regards to 3C, we heard testimony during the trial from the state's own witnesses that, unfortunately Ms. Owens did come to Susan Lorinc's home that night, and multiple state witnesses testified that she was banging on the door and the sliding glass door aggressively. Susan Lorincz has absolutely no prior criminal record whatsoever, and by all accounts from the witness testimony here today, she was a productive member of society and has been almost her entire life. She fired one single shot through a door, so it's the defense's position that this was committed in an unsophisticated manner, for which she has shown remorse. I think throughout the trial testimony regarding the letter that Susan had wrote to the children during her interviews, as well as the statement that she has made here today, I think it's clear that she shows remorse for what happened. Based on all the testimony, we would ask the court to depart from the sentencing guidelines and sentence her to, I think it's 538 days credit time served and probation, so that she can get the mental health treatment that she needs as a condition of that. That's all that I have, Judge.
So your recommendation is probation?
Yes, sir.
Credit for 538 days?
That's correct, Judge.
Is there any, from the state, is there any mandatory minimum, fines, fees, sentences that apply?
No mandatory minimums, Your Honor.
Okay. Yes, sir.
Your Honor, in regards to the downward departure arguments made by defense counsel, one, the claim that the defendant requires specialized treatment and is amenable to treatment, the state would argue that the defendant's PTSD diagnosis was not the cause of this shooting. We've heard testimony today, and it seems that the area of the defendant's social functioning that has been affected by her purported PTSD the most is her ability to form close relationships. That's not the type of behavior involved in this case. The defendant's worst period of PTSD symptoms were when she was in her 20s. That's about 40 years ago. The defendant has only reported seeking help for PTSD twice in her life that we know of, one in the 80s and one approximately 5 years before this incident, but there's no treatment notes. Just a 4-page document is the only information we have. The defendant, we've heard that she's quit treatment, that she does distrust providers, that she has not stayed with any type of treatment that she's had in the past. And so there's not a reasonable possibility that such treatment will be successful. There's also mental health treatment that is accessible to inmates in the Department of Corrections. And when the defendant made her statement, she listed many things, many problems, including 25 knee surgeries, and a host of other medical problems, but I believe the only mention of PTSD was the statement that I know I have PTSD. So, Your Honor, again, PTSD was not the driving force in this case. It is not a basis for a downward departure. Number two, whether the defendant had the capacity to appreciate the criminal nature of the conduct involved in this case or confirm her conduct to the requirements of the law, and whether or not that was substantially impaired. Your Honor, the defendant had the full capacity to understand what was going on the night of the incident. The defendant took pictures. She took cell phone videos of what was going on leading up to the incident. She knew what was happening. She confronted the children about what was happening. She called 911 and talked about what was happening. She talked about her statements to police about what was going on in the apartment, about being in the bathroom, washing her hands, going to the kitchen, getting the gun, returning and shooting Miss Owens through a locked door. And she claimed she all did it in self-defense. This was not an instance where her nature or her ability to appreciate the criminal nature of the conduct was impaired, nor was her ability to conform her conduct to the requirements of the law were impaired. Again, that is not a basis for a downward departure in this case. As to the victim was an initiator, willing participant, aggressor, or provoker, again, this is not a situation where Ajike Owens just walked over to the defendant's apartment for no reason. There's a history of the defendant having issues with the children and Miss Owens responding to those issues. The night of this incident followed that exact same pattern, and the course of events were set in place by the defendant engaging with the children. In the defendant's interview, she admitted she told the children on the night of the incident, "Go get your mom, I don't care." Again, Ajike Owens did not walk over to the defendant's apartment with a gun, a knife, or a weapon. She was not trying to break into the house. She was not the initiator, willing participant, aggressor, or provoker. That is not a basis for a downward departure either. Was this offense committed in an unsophisticated manner, isolated incident? Defendant has shown remorse. As to being sophisticated, I want to point out the defendant had access to two guns that night, a .22 caliber and a .380 caliber. She went and retrieved the larger caliber weapon in this case, not the .22. She grabbed the .380. And this was not an incident where the defendant did not know what was going on and fired a bunch of sporadic shots in fear. The defendant fired one aimed shot at the door that struck and killed Miss Owens. And again, this is not while the shooting may have been a one-time event. Again, this was a pattern of behavior involving the children and the defendant and Miss Owens in this case. Your Honor, there is no basis for a downward departure in this case. The defendant has failed to prove that there is a valid legal ground to support a downward departure. Based on the totality of the circumstances, the court should not depart. The defendant took the life of Ajike Owens, a 35-year-old mother who was her neighbor, and Miss Owens was a mother of 4. The interests of justice are best served by sentencing the defendant to 30 years in the Department of Corrections, which is the maximum sentence in this case. So in addition to 30 years in the Department of Corrections, the state would also ask for $100 cost of prosecution.
Anything else?
No, Judge, I just need to make a couple objections for the record.
Sure.
On the score sheet?
Yes.
Okay. Judge, I just want to object to adding the 18 additional points on the score sheet for the firearm. Just in case this becomes an issue with the case law down the line, she's already charged and convicted of manslaughter by use of a firearm, which in and of itself enhances it to a first-degree felony. So adding the 18 additional points I think would be improper, so I wanted to object to that. And then also there was a PSI done in this case.
Where is that? Where is that at?
On the score sheet, I think it's on the second page.
I believe so, Judge.
What is the state's position on that 18 points?
We believe that the 18 points is validly added. There was a finding made by the jury in this case, and I also have a case. I've given defense counsel a copy. I have a copy for the court. It's out the 5th BCA, Lewis v. State, 952, Southern 2nd, 1271 from 2007, which I believe is on point in this case, and states that in a situation like this, 18 points for use of a firearm is allowed. So I would approach your Honor.
Yes, sir. That was for a manslaughter by firearm offense.
I'm sorry, Your Honor.
The offense in the case is a manslaughter by firearm.
I believe so, Your Honor, because it was reclassified to a first-degree felony
Right.
based
Well,
on the evidence, the undisputed evidence that the defendant used a firearm.
It says in the first line it's manslaughter with a firearm. So
Oh, I'm sorry.
Rhetorical question in that regard.
Okay, I apologize.
What's this defense position on this case?
Judge, I'll only note that if you look at the second page, it's kind of close to the bottom in the paragraph where it says, the court also noted that it's not essential that the weapon used during the charged felony is a firearm in order for reclassification under section 775.087 subsection 1. But in this case specifically, it's the firearm that requires it to be hands to a first-degree felony, so that's why I wanted to make that objection for the record.
All right. I'll overrule the objection based on the Lewis case.
Yes, sir. And then I believe there was a PSI done in this case. I think the court
Yes,
has a
ma'am.
copy of it. I'm
I've
not sure
looked at
if the court has looked at it and relied on it. The only objection I wanted to make to the PSI, there were a few letters that were included by the probation officer that were typed. They were not authenticated, not sworn. So I would just ask the court to disregard those letters.
Okay. I would just, it's in the PSI, whatever's in the PSI I've looked at. I don't generally look at letters and other things that are in PSI, and I didn't put any weight on them in this case. The reason I do that is because I think I've pretty consistently over the last 17 years sentenced the same, pretty much on the nature of the offense, whatever the person's prior record might be, and whatever I think they may do in the future. I think that's pretty much how I do it. If I start looking at letters from friends, well, the problem is that I may give a break to someone because they have friends, and someone who doesn't have friends doesn't get that break. So I simply never do that. I sentence everyone pretty much the same, I think, over that period of time. I do find that the defense has produced evidence that she would qualify for departure because she has for a mental disorder. I think they found, I find they've proven she has PTSD, which is a recognized mental disorder, and is unrelated to substance abuse or addiction, and that she is amenable to treatment. So I do find she would qualify for that departure. On your second one, the capacity of the defendant to appreciate the criminal nature of the conduct, I don't find there was sufficient evidence to prove that departure. There was no indication that she ever did not understand what she was doing, or that shooting at a person would be against the law, or that she couldn't conform with the law in any way. As a matter of fact, she seemed to be, prior to the shooting, calling the police. So it didn't appear to be any situation where her capacity was impaired in any way. I don't find there's evidence that the victim was the initiator, willing participant, aggressor, or provoker of the incident. Otherwise, although she was knocking loudly in this case, there was no real attempt to get in the residence. She kept asking her to come outside. So I don't find that that departure ground has been met. Despite the existence of one legitimate departure reason, even if she did qualify for the other two departure reasons, I would not depart in this case, because I find that the aggravated nature of this case and this offense and the harm inflicted outweighs the mitigation or the departure when I weigh the totality of the whole case. So I find that the seriousness of the offense outweighs any legal departures that could be applied in this case. I'm primarily looking at the harm inflicted upon not only the victim, who of course lost her life, but her family. She has 4 children, all of whom were present during the offense or somewhere in the general vicinity. or at least home, it certainly will have a traumatic impact on their lives for the rest of their lives. They'll live their whole lives without their mother, which I think is a very significant harm inflicted upon them by Ms. Lorincz. When I look at the nature of the offense, I find that the shooting was completely unnecessary in this case. Ms. Lorincz was behind the door was locked. She had already called law enforcement. They were en route. She knew they were en route. She was in a relatively safe position. For some reason, she went into her room and found a gun. She could have stayed in the room and put another locked door between her and Miss Owens, but she came back out, put herself in front of the door, and at the time she fired the gun through the door, she was safe. Miss Owens was simply, although she was clearly banging loudly and was probably very angry over the whole situation, it appears to be she was mostly demanding that Miss Lorincz come outside, which would indicate she had no indication of coming inside the house. So when Miss Lorincz fired the gun through the door, she did so knowing a person was directly on the other side of the door. And she knew that person wasn't a burglar, she wasn't a robber, she wasn't a rapist. She knew she was probably upset about the interaction with the kids, but she had arguments with her before, and no real harm came other than, I guess, a sign was thrown at her, paper sign. And that's when she decided to shoot. I find that the shooting, when I listened to every aspect of the trial and every aspect of sentencing here, it's the facts don't rise to a murder charge, but they are very aggravated manslaughter. Because this case, the shooting was based, I find, more on anger than fear. I think that's pretty well established in this case. So when I weigh it out, and believe me, I find that she's a victim of child sex abuse, was a significant mitigating factor, and she has no criminal record, which is also a significant factor. However, we also have a tremendous harm inflicted upon this family and the victim's family. So what I'm going to do in this case is she be adjudicated guilty of manslaughter with a firearm, and order to serve 25 years in the Department of Corrections. With credit for 538 days. It's $100 cost of prosecution, $100 fine, court cost. Good luck to you, ma'am. You have 30 days to appeal. Is the defense requesting the appointment of public defender for purposes of appeal?
Yes, sir. Just a few more things I want to put on the record.
Yes,
there
ma'am.
was never an offer by the state. The state had asked us to make any reasonable offers. Ms. Lorincz chose not to do that, just for the record.
Okay.
We also did not file a stand your ground motion for strategic purposes. That was also discussed with Ms. Lorincz as well. Just wanted to put that on the record. That's it, Judge.
I will appoint the public defender for purposes of appeal. Good luck to you, ma'am.
Thank you, Judge. May we be excused?
Have a very nice day.
Thanks, Judge.
Yeah, can you bring him to the office? I have a 44.